Good afternoon, greetings everyone. On behalf of RIMS and Prudent, I welcome you all to the panel discussion on liability claims, a subject intriguing and we all want to decode and understand more. I would like to quickly introduce our panel today. We have Mr. Taposh Nandi, Senior Vice President, Tata AIG General Insurance Company. Taposh is a seasoned insurance professional with over 3 decades of experience in general insurance. We have Mr. Mrinal Ojha, partner Solaris Legal. Mrinal has 2 decades of experience in dispute resolution with special focus on insurance and reinsurance law. He has been recognized by leading legal industry publications such as Legal 500 for his work in dispute resolution. We also have Ms. Disha Sahani, Associate Director, Central Insurance Team for Flipkart. She has overall experience of 14 years plus in corporate insurance. Currently, she is associated with Flipkart Group, managing insurance and diversified portfolio across various lines. We also have Ms. Jyoti Krishnan. She would be moderating the panel discussion today. Jyoti is the National Head for Liability Claims at Prudent Insurance Brokers. She is a lawyer by qualification and has more than 10 years of experience in advising several domestic and foreign clients on various aspects of liability insurance claims. With this, I'll hand over to Jyoti to take this forward. Jyoti, over to you.
Thank you, Deepak. Good evening, everyone. Thank you for joining us. Quick announcements about the time, etc. So we'll have a panel discussion for about 50 minutes, followed by Q&A for 10 minutes. Diving right to it, liability claims is a subject that sort of never goes old. Indian laws have been evolving every day, whether it be enactment of new consumer legislation or be the overhaul of the goods and service tax laws. We've seen newer facets being added to the liabilities of companies on an ongoing basis each passing day. Liability lines of insurance take care of such unknown liabilities that corporates or their directors and officers may face. There are several types of insurances which form part of the liability line as such. To name a few, we have the directors and officers liability insurance, commercial general liability insurance or CGL policy, commercial crime, professional indemnity, cyber insurance, so on and so forth. A typical DNO policy takes care of the liability of directors and officers of an organization in connection with any wrongful act that may be committed by them in their official capacity. A DNO cover is typically for the individuals and not for the entity, save and except a few extensions like employment practice violation extension or securities claim. A CGL policy is a policy that pays for damages that an insured company becomes liable for on account of bodily injury or property damage arising out of their business, their product, or their premise. A commercial crime policy indemnifies an insured against first-party losses suffered because of any crime, whether it be forgery, fraud, robbery, theft, which primarily involves their employees with or without the collusion of third parties. A professional indemnity insurance is basically an insurance for losses which are incurred by an insured due to claims out of alleged or actual breach in their performance of professional services. Typically, it involves negligence or error or omission. A cyber policy, similarly, is designed to provide financial protection for first-party as well as third-party losses arising out of unauthorized access, phishing, hacking attacks, and other computer-related losses, as may be mentioned in the policy. As you can see, these are just illustrations. These are types of some of the liability policies. There are many more, and depending on the sector of operation a business sort of works in, different policies come into play depending on the risk involved. Now, moving directly into what are the different risks, what are the different problems faced, we'll now invite our panelists to answer some questions that we all are very eager to sort of get answers to. Starting with Mr. Nandi. I have a common question actually for all three of you. We'll start with Mr. Taposh Nandi. The number of claims under the liability policies have seen an unprecedented rise as far as the last 5 to 6 years are concerned. There have been many new regulations And there's been an increased awareness among corporates and individuals with stronger enforcement provisions. What has been your experience in this regard in terms of the trend of liability claims?
First of all, thank you, Jyoti, for organizing this very this intense knowledge session on liability insurance. And good evening to all participants. What you had very nicely said that the increase in liability claims are generally driven by change in regulations, customer awareness. But the primary trigger for all these kinds of liability insurance is massive increase in connectivity, communication, and connectivity in infrastructure, which is integrating our Indian economy to the global economy. And as a result, we are now competing with the global competition. This basically intensification of competition is resulting in sometimes rushing the product and services to the market. Sometimes basically you're overriding certain risk procedures which are inbuilt in your system, or sometimes you are just ignoring those risks and just going ahead and releasing the product and services in the market. So this is one of the reasons which is basically driving large number of liability claims, that you are rushing the services to the market without necessary checks and balances, which should be in place. The main triggers under the various kinds of liabilities that we see, especially under D&O, we can just categorize it under one, regulatory and statutory, like claims triggered out of regulatory and statutory bodies, SEBI, for example, MCA, for example, or Competition Commission of India. Sometimes they are even charging the insurance company, the insured and their directors for colluding in price fixing, so on and so forth. You will also get a lot of notification from legal and metrological department for tampering with the weights, or weights and measures are not in line with what is written on the labels. A lot of litigations are also coming from or notification and action basically initiated by by SFIO, EOW. These are also various regulatory government bodies which are basically coming up after the directors when there is a major incidence of mismanagement that we have seen in several of the big finance companies recently. On the other hand, other liability claims which we see is basically arising out of breach of duty or negligence. Breach of duty primarily this drives claims under E&O, errors and omission, and PI insurance. Negligence is also there under a lot of claims which we are coming across under E&O insurance. Contamination claim under CGL policies or product liability policies, which is resulting into bodily harm or other kind of property damages because down the line the customer's products are getting affected. So these are another section of liability policies which we are triggering a lot of claims. There is also shareholder action. Some of the investors who have invested in a company, especially when we see a lot of these e-funds and startups are coming up, sometimes the returns are not, or the management of the company is not in line with what these funds must have envisaged. So they are sometimes filing criminal cases against the directors. And there also we are seeing a lot of claims which are getting triggered. Obviously, there is EPLI claims, mainly in US jurisdiction and some European jurisdiction. EPLI claims are basically driven by discrimination due to age, discrimination due to race, unlawful termination. So those are the primary drivers of EPLI claims. And obviously, we are seeing a lot of data breach incident, not too much of cyber ransomware, but there are data breach incidents, especially from some software companies where the developers accidentally share the access code for GitHub or other development portal with some other third party, or sometimes they download the data on their laptops, which they are not supposed to do. So those kinds of claims are also there. So overall, there has been substantial increase. Maybe I should say the volume increase has at least gone up by 25 to 30% over last couple of years on year-on-year basis.
Thank you, sir. Disha, similar question to you. You've been involved in the insurance sector in all your roles rather over the past 14, 15 years. What has been your experience in terms of the increasing trend of liability claims, not just frequency, but also value? So what has been your experience here?
Yeah, so firstly, thank you, Jyoti, for having me on the panel. I think it's a very esteemed panel that we have. And I think Taposh sir, captured the nerve of the problem absolutely clearly. So yeah, I think there is no second thoughts about the fact that the claims have, splurged over a period of last couple of years or a little more than that, especially on the liability lines. And I think predominantly for the last 2 years, all of us know the remote working has only added to the woes. So, so what we've seen as trend is, the cyber, the employment practices related claims, the professional indemnity related claims, all of these claims have suddenly, sort of gain momentum in terms of knowledge, in terms of reach, in terms of people knowing their, legal rights as to, as employees, for example, they know that they have such a right available and they're exercising it. So I was actually doing some research this morning before coming for this webinar, and I figured out that the liability claim notifications over the past couple of years have gone manyfold, as close as 150% of what it was maybe about 3 to 4 5 years back. And the major contributor in last 2 years has been employment practices related litigations. Again, rightly mentioned by Taposh sir that predominantly it's around, improper termination or discrimination among the employees. And people are coming and raising that as an alarm internally and, going out and speaking about that. Second, of course, a large component of this is to be put on cyber, as I said, cyber related claims, data breach, or, sort of negligence on behalf of employees, or, or things like wherein, automation and disruptive technological advancements that have come into the foray. All of this is adding adding value and volumes to one, the exposure, and subsequently the claims. Last point which I want to make under this is that 2021 was labeled as the year of startups. So a lot of mergers and acquisitions, a lot of new companies coming in, mushrooming happened. So all of that has made our environment a lot of a contract worthy environment, as I call it. I mean, a lot of contracts getting into the getting into place. People are wanting to tighten up their liability against third parties, etc. So all of that is one, of course, people are recognizing that there's something as liability insurance available in the market. Two, they're also using it. I mean, they're trying to grasp the understanding of the product and how and where they can apply it. So I think all of this put together has contributed, to the overall claim environment under the liability insurance.
Thank you, Disha. Moving to you, Mrinal. As a lawyer who practices in this area of law, and we always say that a policy is tested when a claim arises. So what would you say that what has been your experience of policies getting tested now?
Right. Thank you, Jyoti, once again for inviting me on this privileged panel alongside Mr. Nandi and Ms. Sani, and good afternoon to all the participants. I see a very healthy attendance in the participants panel. So our experience as dispute resolution lawyers, one can imagine only comes into picture if there is a problem as between an insurer and an insured. So I would say that experience is still a relatively smaller portion of what insurers and insured generally see between themselves, because a lot of those, and this is probably a misconception that sometimes people harbor, that where there is an insurance claim, there is a dispute. In most cases, there isn't any. And there is an ongoing relationship between an insurer and an insured. In terms of the experience that we have seen, or where the problem areas are, I can tell you for a fact that when these products had started out in the market, because they're relatively newer in the Indian context, I say relatively newer, they've still been around now for close to 2 decades. There were issues which now seem fairly straightforward and simple, and insurers or insured would not necessarily engage with or need to engage with lawyers on. There's a far more sophistication within the insurance companies themselves, and with a lot of the insured who are entities who've got, people like Disha on board, who are able to navigate these products. Now, I'm just generalizing liability insurance products. They are ultimately a slightly complicated contract. It's not like your 2 or 3 pager policy that you can read cover to cover very easily and then get over and done with. Because there is a lot of text in that, and there is elasticity of words, there are always times when people are looking at the same clause but reading it differently. Now, like I said, there is somewhat of a landing on some of those over a period of time of how you have to look at certain clauses. But for the most part, we are still relying now, insofar as the judiciary is concerned, we are still relying mostly on overseas precedents and trying to second guess that if this went to court or to an arbitration, then how is it that a judge or an arbitrator is likely to look at this particular problem? Because believe you me, no one wants to get entrenched in a long drawn battle in a litigation, although arbitrations have become somewhat quicker, but you don't want to fight that battle. And one difference also, as compared with the more traditional lines of policies, is that after a claim is triggered, there is still an ongoing collaborative process for the most part between an insurance company and an insured. Their interests are somewhat aligned in terms of dealing with the claim from the third party. So there is that tension on whether something is covered in the first place or not. Once that tension is resolved, then it's, really they have no different in interest vis-a-vis the third party claimant, which is to see how best to curtail that liability, how best to defend that particular action, irrespective of whether it's a directors and officers insurance policy or an errors and omissions policy. The one other trend, moving slightly from this sort of experience, the one other trend that we have seen is these policies people used to perceive them as being a lot more relevant for companies with business operations outside India. And in the last 4 or 5 years, we've seen that the quantum in terms of one particular claim, the level that one has to pay with respect to defense costs, with respect to even the ultimate liability, especially on the defense costs, that started increasing even domestically. So there is today a lot more awareness, and thanks to brokers like you who are also sensitizing your clients, that your problem even domestically is going to mean that it's going to eat into your capital, which can be parked as a risk to the insurance company, which is what these products are all about. So it's, I would say the sophistication is growing on both sides, the insurers and the insured. There are still pockets of expertise. So it's not one size fits all. And when you're looking at a broker and you're looking at an insurance company, you are ideally buying into a relationship. You move too fast, and that sensitivity sometimes gets lost. That's on a softer aspect. That's not to do with the policy wordings, but that is still one particular area where I think there probably can be a little more focus on simply on the basis of one claim not getting covered under a policy. Should you just move that relationship because it's not to your expectation? And sometimes the question of, if you look at that contract, not everything that you may be liable to pay a third party claimant or defending an action, there will be bits and pieces of that action which may not fall within the policy. So what one has spent need not necessarily mirror in an insurance policy, because none of these are end of the day blank checks. So you have to still be sensitive about that as an insured, and you still have to be conscious about ensuring that you are not harboring the impression that no matter what I do, it's all going to come out of a pot of the insurance policy. It may not. So one just has to calibrate that. And I'm seeing, at least in the last few years, that sensitivity is definitely increasing.
Thank you, Malal. Actually, that's a very interesting point that you make, that we have to always remember that an insurance contract is also a contract in itself, which means just because my contract has a liability for B, doesn't necessarily mean my insurer will need to 100% reimburse me for the entire liability that I may have contracted out for. So both are contracts, and both will need to be read to understand how far of what is the extent of my liability that is covered and what is not covered, and then accordingly have my expectation set vis-a-vis my insurance policy. Absolutely accept that point completely. Moving into few specifics sort of now. Mr. Taposh, you've been in this industry for more than a couple of decades, and you've literally seen the space transform in front of you. So what would you say are some of the key issues that you have faced as an insurer when you're dealing with a liability claim? Generally, liability lines of business, or specific if you want to.
So Jyoti, I'm not getting into the basic coverage issues, so on and so forth. And neither it should be interpreted as a litany of woes from the insurance companies. These are basically some stumbling blocks that we see which comes in the way to expeditious settlement of the claim, or come in the way for a quick turnaround in the claim. So number one is delay in notification. So we don't see that claims are notified during the policy period. Like financial line policies are basically claims made policies, and you have to notify the claim within that policy period. Sometimes it is neither notified during the policy period, nor it is mentioned during the renewal of the subsequent policy. So I should not put this that this is something deliberate. This is not never deliberate. Most of the time it is not deliberate. It's because within the company, especially large companies, people are driving these claims or these litigations without knowing that there is a policy behind it. Or a claim can be, one can get the reimbursement to a certain extent under that policy. So by the time it reaches the insurance risk manager or the general counsel, it's already litigation is somewhere midway or nearing settlement. So this is one of the big resistance that comes during the settlement of the claim, which becomes a major issue most of the time. One must be also aware that most of the liability insurance is also driven by reinsurance to a large extent. So why it becomes very, very critical to notify the claim during the policy period, because in the subsequent policy period, you may have a different set of reinsurers. And they may not be happy to pick up that risk, which is not coming under their policy. Ideally, for the primary or the cedant, it's the policy is a normal renewal. So the customer feels that I had been renewing the policy and it's a renewal policy. So why you are flagging this delay? And then sometimes they reach out to the IRD regulation, which says that you cannot decline a claim because of delay unless it makes some prejudice to that claim. So these are the practical side. Number one is not notifying the claim on time. Second is incurring legal costs, which is again linked to this, legal costs without the consent of the insurance companies. So that is another, because the policy, most of the liability policies will have a condition which says that any defense cost should be with the consent of the company, of the insurance company. And consent will not be unreasonably withheld. So any settlement or any defense cost that the insured is incurring, they should keep the insurers in the loop. So this is number two, which one of the problem areas which needs to be addressed. The second is unreasonable counsel rates, which Mrinal has also touched upon, and allocation issues. So there may be under the policy where particular legal litigation that one is fighting, there may be covered matter and there may not be uncovered matter. That covered matter which policy does not cover. So like under a typical D&O claim, like there is a notification from SEBI or a action by the regulator, there may be case against the entity as well as there will be summons against the individual director. So what the policy will pick up is the defense for the director. It will not pick up the defense for the entities unless it's a security class action claim or securities claim in certain jurisdictions. So that's where it becomes very, very difficult how to allocate between the entity and between the director. That is a problem area that still remains. And I don't think there is a very straightforward solution to that. But it's an area which crops up very, very frequently. Another factor that we see is not sharing the information, because the insured thinks that the information is extremely confidential and sensitive and I will not share this information. And we want a non-disclosure agreement, and then they'll send the non-disclosure agreement with indemnity clause, so on and so forth. So if you go by the policy condition, if an insured wants to claim under the policy, they have to disclose. So one has to disclose what is there under that litigation or under that claim. And number two, even regulator, IRDA imposes a kind of condition on all the insurers that they should maintain confidentiality. So rest assured that all the insurers in general, they maintain a confidentiality and they will ensure that the information remains confidential. By and large, most of the insurance companies in India, the liability claim is driven centrally, maybe by a very small team. So it will be again in the best interest of all that when the communication goes between, or a sensitive communication goes, it is either encrypted with the password and the password is shared in a separate mail. So this is another area that needs to be addressed, and where the insured needs that comfort that the information that they are sharing will not be leaked out, or it will remain with them. So sometimes we give them the comfort by having a templated non-disclosure agreement, but generally it is not required. Insurers are bound by the regulations that they have to maintain confidentiality. The other is, many a times the settlements are driven by when you are entering into litigation and you see that there are issues in that particular litigation and one cannot defend it properly. Settlements are entered into not purely because of legal liability. Settlements are also entered because there are commercial interests involved. It's also consuming a lot of bandwidth, senior management bandwidth. A lot of nuisance value is there to that litigation. Maybe there will be bad publicity. So those are not, legal liability. But the policy response is purely for the legal liability. So there again, the matter of allocation comes. And that's why we always, most of the insurance company will ask for a legal liability assessment. What are the chances of winning the litigation? And what will be the defense cost going forward till final judgment, to appeal up to Supreme Court. And then they take a balanced call on the basis of all these parameters. But one factor does remain very, very important is covered matter and matter which is not covered by the policy. Sometimes we also find a situation where we are asking insured to settle the matter at, say, a level of 1 million or 2 million, whatever is the amount, but we are strongly recommending that you should go ahead and settle. I remember one particular specific case in US. It was a very sensitive claim. And when we saw the entire litigation, we just immediately asked the insured, go ahead and settle it. The insured insisted, no, if I settle this, there will be a lot of other litigation and other employees may come in and they start claiming from us. So we will fight this litigation. So at that point in time, we made it very clear that we are recommending you to settle at X amount. If you want to go ahead with the litigation, it is your call, but insurance company will not pay more than that X, which we have said. Why we are saying is, when the discovery process starts, when you start looking at the discovery, I'm taking case of an EPLI claim, you find that there are a lot of communication the supervisor has made and a lot of comments which are coming up in the emails, which are detrimental to insured's cause. Other is somebody who was a colleague of the employee, or maybe her teammate or his teammate. They were the witness. Sometimes they leave the company and then become hostile witness. So those things develop at a later stage. And then very, very senior officials from a very large software company, even they get blindsided that this thing can happen. So this is our experience. When we see that a matter needs to be resolved, the insurance company, if they're asking you to go ahead and settle, I think it's the best interest of all concerned that it should be settled. We also are aware of one case which is being heard by SEBI, where we had purely identified that it should be settled. But then insured has has a point there, because he says that this is my personal honor which is at stake. My personal reputation is at stake. So I want to continue that litigation. So there we have respected the insurer's intention and we are supporting that litigation. So it all depends what call you are going to take. But these are the major issues that crop up in case of any liability across all lines.
Thank you, Mr. Nandi. Disha, now, so Mr. Nandi has sort of given us a few pointers on the issues that he has witnessed, especially as an insurance company or as an insurer, rather, I would say, what seems to be the conduct of an insured, which can create issues around claim processing. Disha, what has been your experience here? What would you say are sort of issues that you've come across or you've witnessed in the course of liability claims?
Sure. So Jyoti, honestly speaking, firstly, thankfully, we haven't experienced many liability claims at Flipkart. So we are touchwood blessed right now. So no first-hand experience from this perspective. But yeah, what I overall feel, and I'll give you my answer in twofold. So first is, the legal cost. I think that is one of the major challenges, the defense cost or the litigation cost, as we call them. What is happening is that these days we are observing that this litigation cost is increasing. Now that's on account of various factors, factors like the complexity attached to some of these claims, like examples given by the poster also. Those claims are very complex in nature and they take time. So, and obviously you would want to put the best people on job. So the cost around the complexity, the tenure of the claim, you might end up appointing the forensic experts in some of these cases. You might appoint a legal counsel in some of these cases. So all put together, first challenge, which as a customer I would foresee, is that a majority of my liability limit might get, burnt under the legal cost head. I still remember my early days as an insurance broker, and I'm sure a lot of colleagues at other brokers, Prudent, of course, would agree. We were quoting this one example wherein, and I'm not naming it here, but there was this one example wherein the entire policy limit was exhausted under defending the claim, but the ultimate award had nothing left under the policy to support. So I think one of the major challenges is that how are we ascertaining our limits, and we are making sure that tomorrow, should there be a worst case scenario to get affected under the policy and is admissible under the policy, we have ample coverage on account of the costs and ample coverage on account of the award should there be any. So we have to put all of that together while ascertaining these limits and while choosing the sub limits under various sections. And I'll come to this in my later sections also. Second very important factor, which I believe as an insured, and I've experienced this very recently. So I can say it's understanding the policy, or I would rather put it as lack of understanding the policy. I think what happens is, more often than not, and I think all of us included here, we only read the policy blueprint when there is a claim or an incident like situation. And what happens is that, because we've not understood the policy in principle, maybe at the time of buying it or maybe at the time of renewing it, we possibly do not understand the implications at the time of the claim. I feel not just the insurance manager or the insurance team at various corporates, but also the internal stakeholders, like the litigation team at the companies, or the infosec teams at the companies, the HR folks, the directors, the officers, the board, board members of the company. All of these are the ultimate end users of these policies. And it is very, very important that these people understand what we are buying, how the policy would respond should there be specific scenarios. So what I, as an insurance manager, do to cut down on this challenge is that whenever I'm buying any new policy or I'm renewing any of the policies, I take my user, the internal stakeholders, hand in hand through the roadshows, through the meetings with these brokers or insurance companies, reinsurers, etc., so that there could be a possibility I end up missing some of those very important, pertinent questions to be asked or coverages to be sought. Likewise, there could be something which a broker misses out in terms of understanding our risk. So I think it's a two-way flow of information and understanding, and all the relevant stakeholders should be involved in the entire process. Otherwise, we will end up having unpleasant experiences at the time of a claim. I think this is what I feel from these two standpoints that I feel as a challenge. These are major. I'm sure there are multiple, but what I could identify as a major two challenges is this.
Thank you, Disha. No, I absolutely take your point, and also we'll never be able to sort of exhaustively put out all the challenges, and the challenges are only going to increase. So I think it's a good idea to try and narrow down the key challenges that we're facing from each side, so that we can basically look at solutions that may help clients at the end of the day. Moving to Mridal, as a lawyer, you have a vast experience of having represented clients in disputes relating to insurance policies. Now, what in your view would you say are the most common points of dispute that arise in the context of an insurance policy, particularly liability lines, when they move into a dispute?
Right. Jyoti, I think most of the examples that Mr. Nandi gave are the touch points of a dispute between an insurer and an insured. Now, it just boils down to whether in those instances, both the insurer and the policyholder are able to come to some sort of a meeting point after the extensive discussions on those tricky points. But fundamentally, if you keep D&O policy aside, because I think almost every D&O policy today has something we call a non-rescindability clause, which means that the insurer cannot avoid the policy on grounds of non-disclosure unless there is fraud, etc., and that's a rarity. Like any other insurance product, the first issue that one would face is almost always around pre-inception, the quality of the disclosure to the insurance company. Now, this duty of utmost good faith, it applies to liability insurance products as much to any other insurance product, and it's been around since there was a decision in the 1700s called Carter versus Boehm. So it's for that long that this duty of disclosure and of utmost good faith, not just good faith, has been recognized. But in many instances, like Mr. Nandi was saying, it's possible, and sometimes it's just a question of how the workflow is within the insured. The person who's filling in the proposal form, does that person even have the wherewithal to gather the information, or is sensitive enough of the obligation to gather that relevant information? Because when a claim is notified, then sometimes when you're looking at the chronology and the whole story of that particular claim, you see that it's predating the inception of the policy or the renewal stage of the policy. And like Mr. Nandi said, in a claims-made policy, your policy is done and dusted after that period is over, insofar as a claim notification is concerned. These are claims made and reported policies for the most part. So if you're then notifying a claim, the origins of which were prior to the inception of the policy, naturally the insurance company is going to be concerned about how do they deal with it under this new policy, considering they may have different reinsurance arrangements, and those reinsurers would not be very happy in dealing with those kind of claims. Now, that's one part. That's pre-inception. And I call this the avoidable mess, because most insureds don't want to hide anything. It's usually inadvertent, or it's just a lack of sophistication in terms of gathering the right information. But that becomes a mess nonetheless. The next avoidable mess is just the timeliness of doing certain things, such as the notification of a claim, as well as seeking consent of the insurer before taking any steps, such as settling it with the other side. If it's like an E&O claim and there's suppose a software company which is facing a claim from a customer, then going ahead and settling with the customer and then going to the insurance company means that the insurance company is bound to get concerned about how do they deal with this claim now. Because most of what could have been answered earlier, which is, i.e., what is this claim about? How much of it is covered? Is there legal liability? Are there also some commercial considerations which are now getting mixed up in that legal liability for settlement purposes? Is there an ongoing relationship that needs to be preserved? Is that why the settlement is taking place? Could this settlement have been at a lower figure had this been negotiated differently? None of these questions have easy answers, because everybody is then, with the benefit of hindsight, trying to look at things, and the insured may say this would not have been possible. The insurer may have a different view on what would have been possible. So that's one other avoidable mess. And even though these are complicated products, I would say a lot of these insurance products are very neatly segmented into what's the insuring clause, which tells you what's covered. What are the exclusions, which tells you what's covered and that gets taken out of the policy. And then the general obligations, the general conditions of an insurer and an insured both, so that both know what is it that they need to do in the operational phase of a claim. Once they are faced with a claim, they have this product. How should they be dealing with the insurer in terms of both timeliness and the other obligations of providing information and of seeking consent in a timely manner? These are all, for the most part, avoidable messes. It just means, going back to the drawing board and seeing what one has purchased, and then ensuring that you go by those terms because that is a binding contract. And then you don't want to have a fight over whether this is an irrelevant clause or no harm came to you because I've delayed the notification. Who wants to have that argument? So I'm saying try to avoid those arguments by ensuring that at least those are not the issues that you're ever having a discussion with the insurer about. Yes, you will still be left with a large residuary bucket of things that you may have to ultimately have a discussion with the insurer and back and forth. And God forbid, ultimately a dispute with respect to whether or not something is covered in the insuring clause, whether a particular exclusion, what does it mean? What are the boundaries of that exclusion? Because that can sometimes get a little subjective, especially given the lack of precedence here. And then you pull out various precedents from all over the world. They may not be consistent. So you may find 5 cases on this side and 10 others on the other side. It does nobody any good, but I think that's not a problem that one can wish away. That problem will remain, and over a period of time, it's not a criticism of where we are in the scheme of things. It's a life cycle in the in the liability insurance regime of our country, and it has, I would say, ramped up to such a sophisticated level already that I don't think it's going to be too much time before some of the other problems today are going to be history tomorrow. You're not going to deal with those problems again and again. Only other issue I would say is around dispute resolution, that there is still, when an insurer and insured face an issue, I'm not talking about the policy itself, I'm talking about how a dispute will be resolved. And that, whether there is an arbitration clause in the policy or there is no arbitration clause in the policy, makes a world of a difference on how a particular claim is going to be resolved between the insurer and insured, if it gets to a formal dispute resolution process. Now, most liability insurance policies do have a catch-all arbitration clause. The other traditional insurance policies in the country largely have a restricted arbitration clause, which says only quantum disputes can be arbitrated, but liability issues cannot be arbitrated. So which means that you're fragmented between, going to a court, and only if you're facing with the issue of how much is to be paid, not whether something has to be paid, is when you will arbitrate. So that's one particular issue, because nobody wants to spend about a decade plus in a courtroom. And I think mediation is the next step, which might make some of these things easier, which is a dialoguing, which may not always be possible with the public sector insurers and the insured very easily. But I would imagine, and Mr. Nandi will bear me out on this, that the insurance companies are as commercial minded and as much corporates as any of the insurers that they're dealing with. And they also don't unnecessarily want to elongate matters. So if there are sometimes instances where it's becoming difficult to pinpoint on whether something is covered or not, there may be an avenue not to get to a full-blown dispute, but to mediate a particular dispute, and on a commercial basis come to some sort of a negotiated settlement on that, which does not create a precedent if that's what an insurance company may be concerned about. So that's a, nobody wins or nobody loses sort of a situation, which one will have to keep an open mind about, given how lengthy litigation, how expensive litigation can get on the insurance side. But otherwise, all the problems that Mr. Nandi had laid out, and the ones that Disha had, touched upon in terms of their problems of the expensive legal costs, those are the touch points of all the disputes, mostly around allocation and reasonableness. Besides the other avoidable mess, this is probably some of the unavoidable mess. Unless you take consent in a timely manner and you say, this is what I'm getting for this much, and this is what I'm planning to do, you may be able to reduce a little of that mess also.
Thank you, Mrinal. That was a good comprehensive sort of approach on the various and particularly the whole avoidable and unavoidable situations, because what you can avoid, you must avoid. If you can, then that should be the aim, because getting into disputes is not going to help anyone. Now that we've discussed the issues that sort of are faced when we're dealing with a liability claim, Taposh sir, I'll come back to you for what do you think are key steps that an insured can take to smoothen their claims experience? In your earlier sort of bit, you were talking about issues that we face, and all of those issues at some point are within the control of the insured. So what are your thoughts on what an insured can do to sort of better their claims experience?
Jyoti, actually, Disha has touched upon those critical issues. Number one, when you are setting up the policy for that particular year, or a policy is getting renewed, one should not just focus on the sum insured or the deductible or the policy rates. One should look at the overall business exposure and which territories the insured business will be expanding in near future. There will be a particular SBU which has not yet come up, but will come up in a new jurisdiction. So Disha has very nicely mentioned that one should involve all the other stakeholders, mainly the legal department, because liability claims are mostly driven by the legal department, and the general counsel will be driving it. The SBUs, the strategic business unit heads in each of these territories, or if they are in a separate jurisdiction, separate territories, excepting territories like Saudi Arabia, China, where it's a totally different situation. There you take it or leave it kind of a exposure you have. But one should take their buy-in, and what are the challenges that they may face, what kind of challenges that may crop up in those jurisdictions or that particular specific business process. So it's very, very important that you loop in the HR team, because a lot of EPLI related claims or employee notifications will be first flagged to HR. Sexual harassment claims will be first flagged to HR. Then you have all the litigation. So your legal counsel or general counsel of your company or the legal head of the company should be kept in the loop that there is a policy. And all the major stakeholders, the users of this product, like the board members, the key officers within the company, they should be made to walk through the entire process, because sometimes they may have retired or resigned from the company and the litigation has cropped up at a later date. They are no longer part of the company. The management has also changed. They don't have access to that policy. So they have those challenges. And one cannot, then the insurance company will try to say that you have violated this policy condition. That poor gentleman does not even have that policy with him. So those are the learnings that needs the insured should always convey all these markers of various conditions, coverage, and the exclusions to the various stakeholders and how the information should flow. So by doing this, one can do that, but one can avoid a lot of complication. The second is be in touch with your legal department, and whatever are the ongoing litigations, which you are aware as a risk manager in your company, and you are also aware that your litigation team is driving it. It's not that insurance company will give you the feedback. The feedback, insurance company in fact wants the feedback from the insured. So there has to be a kind of a feedback loop which is coming in from the legal department. Say, for example, if the policy retention is say $500,000, and if the litigation is going on in some European jurisdiction or in some other jurisdiction. So at least when the legal cost exceeds say 50% of the retention value, you can just mark it that this case litigation may get into a major litigation, and you should now start involving the insurance company and keep them updated with what is happening on those litigations. Alternatively, you can have the list of litigations which are ongoing, have a joint call with the insurance company on a quarterly basis, that what are the developments which are happening on those litigations. And if there is any significant movement is there, then the insurance company can also be made to associate with that defense. Because what a customer is seeing is only that particular litigation, but insurance company must have seen similar litigation with other insurers. So the best practices for handling that particular litigation can also be conveyed to our insured if it does not reach that stage or before it reaches a settlement stage. So this is number two, that if one should have a periodic meeting with the internal stakeholder like HR, legal team, and then convey summary information to the insurance company or to the broker. Broker can again then reach out to those stakeholders, summarize what is happening, what are the pertinent points, and then you flag these points to the insurance company so that they are also aware that what is happening and what are the steps that needs to be taken to safeguard the interest of insured in these cases. So these are the pointers that can be taken into account while avoiding the kind of situation that we come into.
That was really helpful, Mr. Nandi. In fact, it's given the position that you are in, you are also able to throw light on issues that you've seen that ultimately become areas of concern when a liability claim arises. So, as they say, prevention is better than cure. Yeah. Taking these into consideration can definitely help an organization to streamline their processes so that when a liability claim arises, they can make sure that the process is smoother, simpler, and also faster in many ways. Disha, is there anything you would like to add in terms of one, what an insured can do, or if you feel, is there anything that you, as an insured, you feel that your insurer may be also able to help in the process of streamlining things and smoothing the whole claims process?
So yeah, so I'll answer it in two parts, Jyoti. One is what we can do proactively and what we can do after the incident or claim has happened. So firstly, proactively, I think a lot of emphasis I would again want to put on the placement process. I very often use this statement when I was dealing with customers then and now with my team and internal stakeholders, that insurance policy is just a piece of paper unless a claim hits. And when it does hit, more often than not, we'll not be able to go back to the policy document and the placement process, right? So at the time of placement, instead of putting our entire impetus on how we can cut the cost, how we can, sort of negotiate harder, etc., I think the focus should be on seeing what sort of enhancements we need, what kind of, limit increases we can focus at, what are the new add-ons which are there, can we look at the sublimits to be enhanced, etc. Because when the claim would hit in liability, this is high severity, low frequency claims. So whenever, if at all, the claim hits under liability aspect, it'll be for sure a big one. And that point in time, we'd be sort of repenting on a lot of crores rather than lakhs, which at inception, if we could spend, we could stop those crores from missing out. So I put a lot of focus on the fact that even if we have to spend some extra lakhs and we can negotiate something better in terms of coverage and limits, I think that is better rather than doing corner cutting at the time of renewal. So that is point number one. Point number two, again, on a proactive basis, what I would like to say is, a company like ours, we do a lot of contracts, and these contracts are many-fold. I mean, with our suppliers, with our seller partners, with our customers, with our, service providers, and a lot more. So when we are doing these contracts, either we are taking some liability on us, or we are trying to pass it back on to the other party. So when we do this, and this is where your point comes in, Jyoti, where you said that what kind of, support you would expect from your partners like brokers or insurers. We want to make these contracts so tight and so, scrutinized that tomorrow, should there be a claim, one, there shouldn't be a gray area, and two, we are not at any given point in time taking unnecessarily extra liability on us in any shape or form. I'll give an example. So of late, we were doing a contract review with one major, sort of seller on our portal, and we figured out that the limit that they were expecting from us under one of these liability policies was obnoxiously high. I mean, while that is an important partner for us, we really wanted to go to the root cause as to why they were asking for that kind of a limit. And then we deliberated, argued, and then came on to a conclusion that why a particular amount is sufficient, which can float over multiple contracts rather than having high limit under each individual contract. So that's where I'm coming from. I mean, how we can proactively prevent ourselves into getting into situations wherein our policies are exposed beyond how much they should be. I think that will be a great starting point. And lastly, on the if the incident has happened, if the unfortunate claim has come to light, then what we could do, I think, having spent a significant time on the other side of the table, I genuinely feel, and I agree to Mrinal's point also, I genuinely feel that the brokers or insurers who are placing the policy to ultimately pay the claims should they come, but of course in the given framework of the policy. So we should involve our broker partners, consultants, and insurers, the insurers, as the case may be, right from the start of the claim, right from the notification piece, rather than doing what the poster said happens in a lot of cases, wherein you are midway of your litigation process and then you are letting your brokers and insurers know. I think the brokers can handhold you really beautifully if you involve them at the right point in time, and they can guide you through the entire process. And more often than not, you would see that your claim outgo is actually contained, and it is contained appropriately, and you're not going to pay out of your pockets. So I think that is how I would like to summarize as to how we can cut some of these challenges.
Thank you, Disha. That's really helpful. Mrinal, now coming to you, what are the steps you think could be taken in the context of liability claims, which will reduce disputes between insurer and insured, or enable dispute resolution in a quicker and efficient manner? I recall that I think in the beginning you touched upon mediation and ADR as one of these options. Perhaps you could elaborate a little bit on those.
Right, sure. Jyoti, I have very little to add to what Taposh and Disha have said with respect to trying to minimize the areas of concern between an insurer and insured, and to do things in a timely manner. So I'll just park to that side. There's really nothing for me to add to that. In terms of the actual dispute resolution process itself, I think everybody needs to take a long, hard look at the provision that you have in the policies. By and large, they may be arbitration related. Whether that should be mediation and then arbitration, that's one thing for insurers and insured both to consider, because in the event of a dispute, now let me put it this way: your best case situation is to try and avoid going to court or to an arbitration. It's already then put you in an adversarial and in a confrontational position if it's come to that. So some of these things like allocation and reasonableness, which are subjective, inherently subjective in nature, there is some guidance in the policies, differently articulated in different policies, but there's some guidance on how that should be dealt with. But it will eventually boil down to a discussion still, especially because if you've got a situation where you've got a covered and an uncovered matter, and you are spending costs on one legal team. Now, let's suppose you're facing a claim as an insured, but you're also pursuing a fee claim. And you're just using one set of lawyers who are not segregating appropriately how they are dealing with that part of the matter where you are pursuing for your fee, as opposed to the part of the matter where you're looking at defending the claim against yourself. Now, that is going to boil down to some element of how much fee versus how much claim, and how realistic is the fee claim, or is it sometimes, insured say that it's a defense strategy, but there is no real merit to that particular claim. So those are the discussions that will take place. On reasonableness, again, one way to avoid it, if you've got a situation where you've got some people who are covered and you've got some people who are not covered, or an entity which is not covered, then how do you deal with that? Ideally, segregate the defense upfront so that you don't have, because these issues come when you've got one common, let's say one invoice, and you've now got to fragment that invoice into different, uncovered, covered matters, or people who are covered versus the entity. So to the extent possible, you segregate it at the outset so that only the covered person is being dealt with by that particular lawyer, to the extent possible. Sometimes that doesn't happen, but if it doesn't happen, then you boil down to actually a negotiation. If it comes to dispute resolution, mediation is going to be quicker, but it's going to be slightly newer. And it may not lead to a settlement, but it'll give you a good idea, both the insurer and the insured, on what a third party independent, i.e. the mediator, really thinks about the merits and demerits of their claim. If it comes to arbitration, you will be hard pressed to find many arbitrators who have the experience in dealing with these products. So we've now done one E&O arbitration start to end. And it was quite a challenge to first just explain the product to the arbitrator. I mean, they eventually, they're all, for the most part, former judges or people from the industry who will get it, but it's just still an uphill task. So, which is why I say that it's still avoidable. If you're in court, then best of luck to both sides, is all I can say. But that's a really long run battle, and with an uncertainty on what's going to be the outcome.
So that's absolutely true. And as you said, given the product, it may have been in the market for quite some time, but still it's a niche industry, it's a niche product in that sense. So in an arbitration or mediation, to actually explain the product first to the person who will decide the fate, that is also an equally important job. It's not just about representing your side, it's also about letting them know the intent of the policy, because without that, you can never be sure about the outcome. Even from either of the sides. It's not just about whose side you're on. No, the point is absolutely taken. We are at 5 right now. So I think I'm going to invite last key comments from each of the panelists before I open the Q&A session. So starting from Taposh sir, we'll quickly take, let's say, last 1 minute quick comments. Anything that you want to say just before the Q&A?
What is very important for while taking a liability insurance policy is don't just bargain on the price, see your exposure, reach out to all the stakeholders within the company, and then decide what coverages to take and what exposures that the policy should get covered. And for which brokers are the best equipped to do it. And I believe that a collaboration between brokers, insurance company, and the various stakeholders within that company is extremely important.
Thank you. Disha, what are your thoughts?
Yeah, so yeah, just to lastly conclude this, I mean, ours is a very, very developing market as it comes to liability insurance. I think we've experienced it all. I mean, be it capacity shrinks, be it deductibles increase, be it, claim trends increasing, all of that. So I think with all of the factors and all of the things that we can do to control, the problems at the time of claim, what we discussed as a panel, I think we're in safe hands. And if all of these things are put to use, the overall liability policy buying process and subsequently claim process, both would become very smooth.
Mrinal, any closing comments before we move to Q&A?
Yeah, given how short the time is, I'll just put it in 2 words: avoid surprises. And so just insurers don't like surprises, as any commercial entity would not, when there's suddenly something has cropped up, which either should have come up in the first place long time ago, or something that was underplayed earlier on has now become too big a problem all of a sudden. So avoid surprises, all I would say.
Fair point. Thank you so much for sharing your experiences and insights with us. We'll now open the floor for any questions from the attendees. Just a reminder, please add your questions in the Q&A box at the bottom, and I'll read it out to the respective panelists. Also, please note, all the comments made so far in this panel discussion and any comments which will be made henceforth are all each panelist, their personal and individual views. They do not necessarily represent their organization's view. So please do not ask any questions which are intended to be organization-centric. Please limit your questions to each panelist about their personal views. We do have a few questions coming in already. So there was a question in the chat box about allocation and how allocation will be discussed and negotiated. But Mrinal and Taposh also touched on both these points fairly elaborately. So I'm going to skip to the next question. Taposh, this is for you. In the context of defense cost covered under liability policies, what are the factors to be kept in mind to determine the reasonability of cost incurred? So because we see in the policies, we always say reasonable cost will be covered. So what are the factors that one can keep in mind to ensure that at least prima facie the costs they are incurring are reasonable or deemed to be reasonable?
So here one should just look at the litigation exposure and choose the counsel or reach out to the counsel which is commensurate with the gravity of that litigation. Say for a very minor litigation in a district court, there is no point in reaching out to a top law firm operating. It makes no sense. The other thing is, if the litigation is in, say, Bombay, you did not go to a lawyer who is based out of Delhi. So try to have the best lawyers which are there within that particular jurisdiction or for that particular court who are the best suitable lawyers. we see very often a lot of cases where the litigation is in Delhi and the lawyer is all flying all the way from Bombay to attend those court sessions. So this is one another thing. So primarily, if they are in the same geolocation, unless the litigation is of such a scale or that you have to maybe reach out to lawyers in every part of the country. So these are the basic markers, and the other markers that I would like to just elaborate one is we expect the law firm to, if whatever the law firm which have been engaged, their invoices should have the full details of the work that has been done and how much time that specific work has taken. So if something research is being done for a particular case, we don't expect that the research to be done by the senior partner. We expect that research to be done by the legal or paralegal or the junior associate in that company. So these are the certain indicators that we can have. We can agree on the rates of the senior counsel or on the senior counsel. If any specific senior counsel, they are already deciding that this particular senior counsel will come at a later stage in that case. If any external senior counsel, which is not from the law firms. So if that can be decided earlier and agreed upon with the insurance companies. So these are the few things, and we expect that single lawyer to perform a single task. It's not that 2 or 3 lawyers are working on the same task or representing the insured in the court. Say 3 or 4 lawyers on the same matter are representing in the court. So, and disbursement should be at cost. And if somebody is flying, say, from one place to another, the cost basically, unless it's a senior counsel, generally the cost is incurred. We pay for the normal air cost, not the business class cost. So then a lot of entertainment expenses should not get billed to the insurance company. That we see entertaining the lawyers or entertaining other or taking the team to a lunch, and that is also getting billed to the insurance company. So these are unreasonable and should not be forming part of the litigation. We don't expect such.
That was an interesting example, sir, particularly about the whole entertainment cost being billed to the insurance company.
Yeah.
Should keep that in mind, definitely, without fail. Milan, I have a question for you as well. Now, the Indian judicial system traditionally has been known to be detail-oriented, which we also can say translates to higher amount of time being taken to sort of conclude an entire matter, whether it be trial or even otherwise. But recently, we have seen that the government is also trying to come up with measures to reduce, if I may say, litigation time. Now, whether that may be through, enacting the Commercial Courts Act so that certain matters can go through those courts, or through, ADR mechanisms, etc. So, what are your thoughts on this? Like, what are some of these measures which are they really helping reduce, the pendency of cases before courts, or, what are your thoughts on how they are supposed to help and are they really helping?
Right, Jyoti, it's somewhat controversial sometimes this kind of a topic, because you people, you'll appreciate that there are extreme views with respect to whether these things are making a difference or not. My view is that it's certainly a start. Now, the 2 changes that you've seen broadly are to the CPC and the introduction of the commercial courts through the Commercial Courts Act, which is aimed at streamlining the process. The flip side of that is that you still have the same courts and the same judges who are redesignated as commercial courts and commercial judges, who are still changing a roster for one day from a family matters to criminal matters to then commercial matters. So it's not static, therefore. And the life cycle of a suit, a commercial suit, it's too early to say whether that's gotten any better. It would still be hard for us to recommend someone to very quickly take the court route, given the time that it takes. Although like I said, it's a start. And because we're in a life cycle of that particular process, other countries have had a head start, in some of those. Insofar as arbitration is concerned, it's one of the biggest changes that's taken place, and there are very few countries, if at all any, which now have a time limit on when you have to finish with the arbitration. So it is 1.5 years. You need an extension, and up to writing the award from the completion of the pleadings, you need an extension, you have to go to the court. The arbitrators don't want their names to be in the court as, you know, people who are unable to finish an arbitration in that much time. And that those extensions don't come for the asking, and they don't come endlessly. So even that 1.5 years will become 2 years at max. There, the issue is slightly different. That's the pool of expertise that you would have to deal with cases. Even if the arbitration is faster, it may not always be better. So I'm just, you know, wearing the black hat and the positive side, both sides I'm giving here. And I think mediation, I strongly pitch for mediation. And one good thing in the Commercial Courts Act is also that now there's mandatory mediation when you're filing a civil suit. Now it depends on who your mediator is, certainly. But one advantage is that during the course of the mediation, you have, instead of two people in their adversarial position trying to talk to each other who've like had a bit of a breakdown in their relationship, there is now a third person in between who is hearing both sides and showing the mirror with respect to their respective cases on, you know, what are the downsides and the upsides of their cases. And I've seen that people, when they go back from a mediation session, they do consider their case differently because they've heard now from another person on what are the strengths and weaknesses of their case. They might get more entrenched in their position, or they might loosen up a bit. But it's your best shot at least having a dialogue outside of just a direct commercial negotiation. And I think the more people use it with the right mediators and sometimes the right institutes, the better it might be. And if it fails, you'll have better clarity going in an arbitration or in a litigation of where you stand really with respect to the positions you've taken.
Absolutely. That's point well taken, Mrinal. There is another question on the increasing cost of defense, but I believe we've already discussed that in one of the earlier questions with Disha. So with that, I'm going to sort of end today's panel discussion. Thank you so much to all our panelists for bringing their insights into giving us their valuable insights. What I also want to request is that I request the audience to please give us your feedback on how the webinar was. You can either go to, I'm just going to present the screen once. You can either go to www.menti.com, enter the code which is on screen, and then leave your feedback, or you can scan the QR code which is appearing on screen. This was a great session. Thank you so much for your time. And I hope all of you had a lot of fun. You were able to ask your questions. Thank you so much for the panelists for taking out time from your schedule and sharing your views with us. And thank you for the audience. Thank you so much. Have a good evening, everyone. Thank you.
Thank you, Jyoti. Thank you.
Thank you.
Thank you, Sandeep.